We have today an extraordinarily distinguished roundtable of former attorneys general. We'll probably talk a little bit more about some of the backgrounds as we go through the individual questions that we have. But if we start on this end, this, of course, is Benjamin Civiletti, served as Attorney General from 1979 to 1981 under President Jimmy Carter. Seated next to Attorney General Civiletti is Attorney General Dick Thornburgh, who served as Attorney General from 1988 to 1991 under both Presidents Ronald Reagan and the first President Bush, George Herbert Walker Bush. And seated next to Attorney General Thornburgh is Attorney General Alberto Gonzales, who served from 2005 to 2007 under our second President Bush, George W. Bush. And immediately to my left, although not politically so, is our former Attorney General, Judge Michael Mukasey, who served, of course, under George Bush as well, President George Bush as well. So welcome to all of them. The current Attorney General, Eric Holder, gave a speech at Northwestern University Law School in March. And he outlined in that speech a fairly broad set of issues that, it's fair to say, attempted to explain the Justice Department's views about how you reconcile questions of process and fairness with the needs of security in the setting of particularly the war on terror. And that was a fairly far-ranging speech. It had a number of different points to it. We've edited down a couple of excerpts from that to tee up a specific issue that we'll start with.
Just as surely as we are a nation at war, we are also a nation of laws and of values. Even when under attack, our actions must always be grounded on the bedrock of the Constitution and must always be consistent with statutes, court precedent, the rule of law, and our founding ideals. Our history proves this. We do not have to choose between security and liberty, and we will not. Now, let me be clear. An operation using lethal force in a foreign country targeted against a U.S. citizen who is a senior operational leader of al-Qaeda or associated forces and who is actively engaged in planning to kill Americans would be lawful at least in the following circumstances. First, the U.S. government has determined after a thorough and careful review that the individual poses an imminent threat of violent attack against the United States. Second, capture is not feasible. And third, the operation would be conducted in a manner consistent with applicable law of war principles altogether. Some have argued that the president is required to get permission from a federal court before taking action against a United States citizen who is a senior operational leader of al-Qaeda or associated forces. This is simply not accurate. Due process and judicial process are not one and the same, particularly when it comes to national security. The Constitution guarantees due process. It does not guarantee judicial process.
What constraints, if any, are there on the President of the United States when you're at war or a war on terror and the person that is the subject is a U.S. citizen?
Well, I find the use of drones, even under the three conditions that Attorney General Holder put forward, to be very troublesome. And I also think it's a slippery slope, that if you have those three conditions and specificity, and also a balance that the likelihood of innocence being affected is minimal, that it's barely justifiable. But to extend it beyond that with less specificity, with less proof of the inability to apprehend, and the imminence of the adverse action by the target, they're all very troublesome if they're determined by a particular agency and not by some more ordinary due process standard or procedure. I hope we are following such a procedure. I'm not sufficiently familiar with the underlying facts to know whether that's so or not.
Judge Mukasey?
Well, unlike General Civiletti, I wasn't troubled at all by the Attorney General's comments, and nor do I find in them anything particularly new. There's a case called Ex parte Quirin that dates back to the Second World War, when a group of Germans landed off Long Island in Florida. Interestingly, they landed in uniform. When you stop and consider that that's the riskiest part of the operation, it's odd that they would do that, except that they then buried their uniforms on the beach, and I think they hoped that if they were apprehended at that point, that they would be treated as ordinary prisoners of war rather than as what they were, which is unlawful combatants. One of them later claimed to be an American citizen. When the case got up to the Supreme Court said essentially that it was irrelevant, that once he had thrown in his lot with Germany, as he did, he would then be treated the same way that a German soldier was. And he was. In fact, by the time that opinion issued, all of the defendants who were prosecuted in Quirin, other than 2 who cooperated and got life sentences, were already dead. Al-Awlaki in particular has an exquisite history going back to 9/11. He was the inspiration behind the shooter in Texas. He was the inspiration, according to the testimony that's ongoing in a court in New York, behind a group of people who were planning to blow up the New York City subways. As far as the imminence, I can't speak to that. And that's the one that gives me a little bit of hesitation. I don't know what was imminent about the Al-Awlaki threat. I know that it was ongoing. And candidly, I would settle for ongoing rather than imminent. So the short of it is, it doesn't trouble me.
I will tell you, in Attorney General Holder's remarks, we didn't have time to play the whole thing. He talks about the window of opportunity as a part of the test, and he says that it is not necessary to wait until the plan matures to a specific time, place, and manner of attack. So again, he was trying to set broader parameters here. And so on your question, Judge, how far in advance can you go? He didn't quite answer it that way, but he did say on the other end, we don't have to wait until we know that the plan has matured to time, place, and manner of attack. So it does raise the question, I think, how much earlier in a process is it permissible?
Well, with somebody like Al-Awlaki's history, it seems to me that unless you tell yourself that he was planning on retiring and going on the speaking circuit, which I seriously doubt, I think you can pretty well conclude that he was about ongoing plans. And in fact, he had videos up. He had a magazine called Inspire that actually inspired people to do things we really wouldn't want them to do. So he was an ongoing threat, and I, again, have no trouble with the question of imminence. What does give me a bit of pause is the question of capture, but not from a humanitarian standpoint, more from a practical standpoint. We could have learned a lot from him had we been able to capture him and interrogate him under the proper circumstances. Obviously, that's foregone with a drone strike. And every time you do that, you're dipping into a well of intelligence that has to be renewed and necessarily can't be renewed if your drone strike is successful.
Well, of course, I dealt, like Mike, with a lot of issues relating to the war on terror. I think if I had walked into the Oval Office, my advice would have been to the President that this was a legitimate target. This is an American citizen who is a sworn enemy of the United States. However, I would have cautioned the President that I'm not sure there are 5 votes in the court that would support that position, quite frankly. When you look at a case like Hamdi, where the court said that the designation of an American citizen as an enemy combatant for purposes of detention, that designation could not be made solely within the executive branch. It had to be made by a neutral decision maker. If you carry that logic forward, it would seem to me that some members of the court would be even more troubled with the notion that the President on his own could designate an American citizen as an enemy combatant. Now, once that designation is made, then it seems to me the president should be free, without any additional consultation with Congress or with the judiciary, to take action as he deems appropriate in the interest of the United States. But again, I think walking in the Oval Office, I would say this is a legitimate target, but I can't guarantee you that if this case were ever litigated, and of course it's a question of justiciability here, and maybe this is an issue that would never be reviewed by the courts, but I would caution that we might have some issues with the Supreme Court if it ever got that far.
The difficulty to me is not in the enunciation of the principle, because I think the principles are stated in broad terms and they're generally agreeable to all of us. The difficulty is in the application, and the specter that is raised in my mind is the absurd and probably unlikely result that you almost have to have alongside every combatant on the battlefield a counsel to advise him or her as to how they should proceed. Now, this is clearly not a feasible operation, but it's the slippery slope, I think, that Ben Civiletti is talking about. Do we require search warrants to go over the top and into a trench, or do we require Miranda warnings given to people that are taken into custody on the battlefield? Clearly not. I'm not suggesting that absurdity is going to result, but it points out the very difficult task it comes to decision makers in the heat of struggle. And in my own balance, I think you have to lean over backwards to give a maximum amount of flexibility to those people who are in harm's way and who are seeking to carry out their mission of war against an enemy that is so demonstrably threatening to the U.S.
Now, if we change the facts just a bit, and instead of assuming that the United States citizen is abroad, we assume that the United States citizen is resident within the borders of the United States. One obvious sort of fact that suggests a little different outcome is perhaps there's a greater opportunity for apprehension, right? And so there'd be more opportunity. But we do have, just in regular law enforcement all the time, I know we were talking, we're on the Supreme Court of Texas, so you know, right? We had just in normal criminal procedure, we'll have cases where there are folks engaged in crimes and the police officer comes in and there's not time to go and get a judge to decide what can happen or not happen, and the officer has to act. So let's assume that we have a United States citizen, domestic now, not abroad, not necessarily chic anyone, but just posing a violent threat. Someone like, I mean, we had, you know, the bombings in Oklahoma, right? So we have domestic terrorists. Under what circumstances then is the president authorized to order the killing?
Let me just say that I'm not going to answer your question. I'm going to give you a different response first. I think what we're seeing, the court is much more attentive to the rights of American citizens in the war on terror, because I think they appreciate and understand that the war is not just overseas. It can be here in this country and will likely reoccur in this country again. And also, the danger of making a mistake in terms of the designation of an American citizen as an enemy combatant is much greater because, of course, our enemy doesn't fight wearing a uniform, doesn't carry arms openly. I think it is for that reason that the court is much more sensitive with respect to the rights of American citizens in the war on terror. And I think, again, if I were advising the president, I would make sure that he understood that in making his decisions dealing with foreign terrorists, particularly here in this country. Obviously, it wouldn't be a foreign terrorist, but dealing with terrorists here in the United States.
Judge?
Well, I did have a case similar to that, although not a question of killing, involving a man named Jose Padilla, or as he preferred at the time to pronounce it, Padilla, who was picked up on a material witness warrant that I issued. It was picked up in Chicago.
Just tell him for a moment, you're talking about when you were sitting on the...
When I was on the bench, right, sorry. He was brought to New York and given a lawyer, as all material witnesses are required to have, I should say. And the government had a certain amount of time within which to either put him in front of a grand jury or release him. And they sort of delayed and delayed and delayed. And I pointed out to the assistant, we don't have a detention statute here. We either have a witness or we have a defendant, which is going to be. gave him until the following Tuesday. That weekend, I got a call from the United States Attorney telling me that the President had designated Mr. Padilla an enemy, an unlawful enemy combatant, was transferring him to a brig in South Carolina, and withdrawing the government's warrant. And then the question became, and what happens before me? And we had government conceded that he had a right to file a habeas petition, although there was a dispute about where. I wrote a long decision, went up to the Supreme Court. The Supreme Court decided I hadn't had jurisdiction. Went back down, went to the Fourth Circuit eventually, which decided the President did have that power. And then just as the case was about to go to the Supreme Court, the government transferred him to the civilian system and tried him on a criminal charge. He's now doing, I forget exactly what the sentence was. But the bottom line for me and for the Fourth Circuit was that the President did have that power. Now the question is, what's the standard of proof? Who's the burden on, and so forth? That's where the devil is, which is in the details.
So let me just give you a little different historical setting to think about this. One of my distinguished colleagues from Seattle, a fine criminal appellate lawyer named Jim Loebsense, when I was chatting with him about this, reminded me of the dust-up between Thomas Jefferson and Aaron Burr. And you'll recall that Aaron Burr had served as vice president for Thomas Jefferson in his first term. They had what could fairly be described as a significant falling out. There was, during that last part of his term, the falling out that Aaron Burr had with Alexander Hamilton. And then after he left serving as vice president, Thomas Jefferson believed that Aaron Burr had committed treason, had an arrest warrant issued for him. He was in fact arrested several times, released by some judges, ultimately captured and put on trial. I believe it was just Chief Justice Marshall that tried the case in Richmond, and the proofs were not quite the same as we had with the Sheik, where we had a number of enemy informants who have given. This was, I think, the principal witness against Aaron Burr was General James Wilkinson, who was the commander-in-chief of the United States Army at New Orleans. And in the grand jury proceedings, I believe, there was a letter that was considered one of the great documents of proof showing that Aaron Burr was involved in this treasonous behavior. Upon examination, cross-examination, I believe the story is that General Wilson acknowledged it was his handwriting, that the letter had been lost, and so he had rewritten the letter himself so that the court would have the benefit of the evidence. And at the conclusion of the trial, Aaron Burr, instead of having a drone kill him, was acquitted and went off to Europe for 4 years and then came back to New York. So we do have instances. Right now we're thinking of this as, okay, well, the president surely would only go after some outrageous cleric. All right? And obviously you have these questions about the immediacy of the attack and so on, but it's relatively clear that Thomas Jefferson genuinely believed that Aaron Burr was engaged in an act of treason, principally dealing with Mexico and Spain and what sides people were going to take. And, you know, had it been up to Jefferson, I mean, the stories are he actually tried to get John Marshall to get the guy convicted. So it's not altogether unknown to our country that you could have the executive branch take it upon itself to use a power somewhat more expansively. And so my question to you is, to what extent are we comfortable that the rules that we're articulating here are bounded not just by contemporary sense of, okay, we're all convinced this is a bad guy, but are we setting up rules that we're really comfortable will protect us when there may be excesses? This is, I think, Attorney General Civiletti's concern.
Let me suggest one way to look at that. It falls under the heading of job descriptions. The law enforcement model that we're used to utilizing involves the gathering of legally admissible evidence that can be produced in open court before a judge and a jury, designed to prove beyond a reasonable doubt that a specific crime has been committed by specific persons. On the other hand, in the intelligence gathering field, designed to thwart any kind of criminal activity or non-criminal terrorist activity or what have you, the task is to gather information and intelligence, legally admissible or not, and to use that in a way that can prevent harm to our institutions and our people. And I think that the difficulty in melding those two into a fabric that is useful in every situation is self-evident. And one of the real difficulties that we have in a lot of these situations, whether they're hypothetical or real, is determining what kind of job description we have given to our government in terms of protecting the country and protecting our institutions and our people. I don't know the answer, but I do know that that question pervades every kind of discussion of these issues.
And don't you think, though, Attorney General, that it's not just a question of what is the job description for the government, but what are the responsibilities within the divisions? Because, I mean, this is really the question that I think Attorney General Gonzales was raising when he said if he went into the Oval Office to talk to President Bush, he'd have to say, well, once a proper determination has been made, however that happens, that this is an enemy combatant, boy, you can go after him. But where I'm a little nervous, as I understand you, is who gets to decide that. It's not altogether clear that you, the president, or any of us in the executive branch get to decide that.
Let me put it this way. Suppose that an FBI agent is on to what he thinks is a very serious situation, posing a real threat to the country. And for one reason or another, he is unable to carry out his usual FBI careful responsibilities of due process, et cetera. And he apprehends an individual and prevents a dreadful attack, let's posit a nuclear attack, on a major institution or center of population in this country. Clearly, the first model, the law enforcement model, has been abandoned, that any evidence that was obtained or action taken would be unjustified. At the same time, I don't think that there's a likelihood that that FBI agent is going to be dismissed or sanctioned or punished in any way for having prevented a Holocaust-type event in the country. More likely he's going to get a ticker tape parade through New York City and honoring his activities. And this creates a whole raft of other problems. That is to say, how far can you press what we all acknowledge to be the proper imposition of due process of law rules in the face of a situation where vast public acclaim has come to this individual? On the other hand, if you don't do something about it, if there isn't some sanction involved for this type of illegal activity, then you lose the power to command your resources in the field. People are going to say, oh, we don't have to pay attention to the rules as long as we get the right result. And if they don't get the right result, then they're going to have to pay a price there. So I find this an insoluble problem, to be frankly, and maybe my wise colleagues here can solve it for me.
I'm not sure that I have a solution, but I will say that for President Bush, obviously he wanted to see everyone brought to justice who committed acts, whether they be violations of law in the criminal justice system or violations of law in the military justice system. But it was very clear, at least to me, that our number one priority was no longer prosecution, it was prevention. And as Dick said, I mean, that requires you gather information, you gather intelligence, but to do so in a way that's consistent with the Constitution and consistent with our laws. But there's no question that our number one priority was prevention, not prosecution.
And so my question to you, though, is how, if at all, does the judicial branch get involved in that? Because in Attorney General Holder's speech, he does say that one of the safeguards that the executive has is that they have made a practice of consulting regularly and keeping informed key leaders of the Congress. And so now we have two of the branches accounted for. But by its very nature, obviously, it's not the sort of thing that, well, I mean, we don't think of ex parte calls coming in. I'll just give a call to the chief judge of the Southern District of New York and chat with him about, or her as the case is now, about what we shall do here. But when you think about it more broadly and you take a step back, if we were concerned about popular sentiment allowing a climate in which the executive might overreach, I don't think most of us would say, why, by golly, the legislative branch is our best check on that, right? I mean, historically, we would say, well, let's look at the judiciary. Now, two of you were judges, so why shouldn't we trust you to get involved in this?
Believe me, other than several federal judges, I'm second to nobody in my admiration for the federal judiciary. But I also recognize, having been one and known several, its limitations. The judicial branch is probably the branch least suited to making determinations of that kind because it is a branch that does not have available to it an independent basis for gathering evidence, or for that matter, the background for evaluating it. There's one thing I think we're leaving out of the equation here, which is the political responsibility and the political responsiveness of the political branches. The president, number one, according to Article 2, has the executive power, and it's not all except a little bit, it's the executive power, period. Secondly, the president is the person who's accountable in the event of a failure. And that, I think, is the person in whom is lodged the responsibility for making the determination. And he will pay a ferocious price if he errs on either side. And I'm more comfortable, frankly, with that than I am with a life-tenured federal judge with not necessarily any background at all, and certainly no independent way of gathering facts, making a determination.
Well, let me just pursue that for a moment, Judge. When you say that our federal judges don't have any independent way of gathering facts, I think most of us would say that's true in every matter they hear, including capital cases. And yet we seem comfortable with the notion that the way the federal judge receives facts is through the adversary system. So the executive branch, operating through the Department of Justice, would be able to inform the judge, and that would be the fact-gathering process. So it's by its very nature, it does include a vehicle for the judge to obtain facts. Is there something about this setting that you think is so different from the other kinds of tasks that we ask our federal judges to do that they lack the skill in order to handle the task? Or is it because ultimately the political consequences, this is, in your view, ultimately a political issue that needs to be resolved through the electorate?
It's more the latter than the former.
Now, it's often the case that we talk about examples from World War II. And in Attorney General Holder's remarks at Northwestern, when he was talking about targeting before he got to the U.S. citizens, he was talking about just generally, can you target individuals like Osama bin Laden? And he gave the example of General Yamamoto, and that in World War II, the military made a specific effort to shoot down the plane that had General Yamamoto in it. It wasn't, we just picked a plane and he happened to be on it. They knew he was on it. That's why they went after it. And he said, and everybody was really happy about, our being able to kill Osama bin Laden. And so there's nothing wrong with that angle of targeting individuals. And so we have these general references to World War II, and this is certainly not an example where the courts are a shining moment. But if you look at what came out of World War II, we also had the Japanese internment cases. And those remain effectively good law in the sense that they have not been officially overruled. I think they also remain largely an instance for many of national disgrace. Our acting Solicitor General, Neil Katyal, has publicly apologized for the role of the Solicitor General's office in misleading the Supreme Court in connection with those proceedings. And so I want to just be a little cautious about looking at what we did in World War II and saying, well, if we did it in World War II, it's fine. Isn't there a risk that in a climate of war, what the political reality is, the president having to respond to political pressures, is really not a legitimate check on what could be a terrible abuse?
I'll just say that when I worked in the White House, of course, when we started developing many of these policies relating to terrorism, we, of course, naturally looked at what had happened before during World War II. We looked at the case at Laqueur, and we looked at the use of military commissions. And what we quickly discovered is that this is a different court, it's a different time, it's a different kind of war. We were fighting Japan, we were fighting Germany. These were nation states. And the court, I think, quickly and decisively reminded us that this is different. This is a different kind of conflict. And it's something that, is this something we should have anticipated? I don't know, but it's certainly something that we learned through the decisions from the court.